So what should you do after a slip and fall accident? What are the steps that you can take to protect yourself and your legal claim? Well, ideally, and if you're watching this video, it may be too late for this, but ideally, you would document everything. You would take pictures of the defect, of your injuries, of the surrounding area. If you speak to someone from the business or wherever this happened, a security guard or an employee, take a picture of that person. Take a picture of cameras that might have captured the incident, fill out an incident report, make a paper trail, make a record, make it beyond dispute as to two things. Where did this happen? And what was the condition of the thing that you tripped and fell on, or the defect on the premises? I had a slip and fall case against the Rooftop Bar here in Nashville, and the key question was whether there was ice on the rooftop. This was in the wintertime. And they denied up and down that there was ice, but we had pictures of ice. It was very frustrating, actually, because the adjuster kept saying, there's no ice on the rooftop. And I was, what do you mean? Look at this picture. So ultimately, we were able to resolve that one successfully. But that was a situation where having cell phone pictures from the plaintiff's phone or plaintiff's family's phone was important. Also, make a list of witnesses that were there. If you were there with your friends or your family, anyone that saw the incident, anyone that might have been there, the more documentation you have, the better. The second thing you need to do, and this is really true of all injury cases, ideally, you will get prompt medical care. In the example I gave you of the Rooftop Bar situation, that client was so injured that she was taken by ambulance straight to the hospital. So there was no question of a delay in treatment. But the longer the delay, generally, the worse it looks for the plaintiff. Insurance companies will look at that and say, well, you're not really that hurt, or you're only doing this to kind of create a medical bill history to make your injury claim worth more. So the tighter the timeline between when you get trip and fall and get injured and when you receive medical care, the better it is for your case. Here's a third thing. The insurance companies will often have someone call you and take a statement and try to figure out what happened. You should call a lawyer quickly if you think that you might have a case like this. And you should not make this statement. And you should probably not make this statement at all until your lawsuit is filed. This is a common tactic that insurance companies will use, trying to get essentially a free pass at the plaintiff before a deposition where the rules of evidence don't apply and the rules of civil procedure don't apply, and they can kind of trick you up into admitting things. Because the thing is this, in slip and fall accidents and premises liability accidents, there's always going to be the defense that it's your fault. That's called comparative fault, and I've got a video on that which we'll link to if you don't know what that is. But they will always try to come up with some basis to blame you, the plaintiff, for your own injuries. You weren't watching where you were going. You'd been drinking. You had the wrong pair of shoes on. Whatever it is. You were on your phone. They will explore all these defenses in every single slip and fall case. It's just their tactics. So don't give them a free pass at you when you haven't even got a lawyer on your side yet. So don't talk to the insurance company. First, talk to a lawyer. The next thing is, and this is again true of all injury cases generally, is that you should document your recovery and your injuries and the pain. If you have to have a ankle surgery or wear a boot, or you have to have a knee surgery or whatever it is, you should document how painful that process is. You should keep a diary of every time you have to drive to physical therapy. A lawyer friend of mine told me he once put up at trial, he had mapped up how many visits that the plaintiff had had to go to various appointments. And he calculated the mileage of that and put it on a map. And it ended up being that you could drive to California and back from Tennessee to, if you had to drive all this time, that this plaintiff had had to go to all of these various medical appointments. That's not something that you necessarily would think about, just the inconvenience and the time of all the appointments. But if you can document it and we can really say every day, how much time you had to spend in traffic, all this stuff, it can add a picture of how much your claim is worth, and it can maximize your recovery. Now, of course, even if you do all of these things, as I was saying earlier, they will still allege the defense of comparative fault. If If you want to know more about that, watch this video.